This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 25 years. Find out more at roundtablegroup.com.
Thank you. Welcome to Discussions at the Roundtable. I'm your host, Michelle Loux, and my guest today is insurance claims expert Kevin Quinley. Thank you so much for joining us today.
My pleasure, Michelle. Thank you.
So one of the questions I always ask before I start my podcast episodes is, what do you wish you knew the first time you were an expert witness?
That's a great question because all expert witnesses have been there. I'd say three things. First is the power of no. We want to be people pleasers. We want the new assignment. We want the case assignment. We want to get traction on our practices, but to accept assignments with incredibly short fused deadlines can degrade the quality of the work product, or if the subject matter is beyond or just at the periphery of our knowledge expertise, it's very tempting to say yes when really you ought to say no. So that's number one. Number two, related to that, is stay in your swim lane. And by swim lane, I mean your subject matter expertise, because it gets real dangerous. And does the client no favors, does the law firm no favors, and does you no favors as the credibility for your future engagements if you venture outside an area where it is really external to your core expertise. And I think the third thing I wish I'd known is the importance of project management, separate and apart from the subject matter, whether it's metallurgy or medicine or insurance claims. I have found personally, a lot of this job is project management, especially when you get a number of cases and you hope to reach a stage where you've got a number of cases, you've got different deadlines, you've got a number of priorities, whether they're trial dates, whether they're deposition dates, whether they are milestone dates for Rule 26 report or disclosure. You're juggling a lot. And so I think the need to at least weekly have a discipline of taking a broad spectrum view of all of your commitments and deadlines and sort of rearranging the chess pieces on the board or the pieces of the Jenga puzzle to triage and prioritize what in mapping out and planning your work week and month and year, and make sure that you have captured all significant dates. Those are three quick thoughts.
So you really do highlight, you need to be organized. Is that something where you take outside classes, or is that something you just learn along the way?
For me, it was to an extent self-taught. I mean, I guess there are classes on project management. I've never taken any. It is an approach I tried to use when I was in a corporate setting, though. So I think it's a transferable skill, whether you learn it sort of through the school of hard knocks and not doing it. You reach a point, whether it's in a corporate setting where you got a lot of things coming at you, or an expert witness, and you've got a lot of engagements coming at you and deadlines. You've got project deadlines. And so I think it's one that, is transferable from a corporate setting. And if you reach a certain strata of a corporation, chances are you won't reach that strata unless you have either innately or by training some organizational skills. Each case assignment is a separate project, and each one has milestone dates. Some of those are indifferent to the expert. Some of them are really key to the expert, and you need to have I keep a chart above my computer monitor of key upcoming dates in sequence. And that sort of dictates the prioritizing of how my work week unfolds. I tried to do the same thing when I was in a corporate setting. So I think it was somewhat transferable.
Yeah, I mean, it's time management as well. Well, one of the things too that's really important about being an expert is the interview process. And so can you just walk me through, what do you normally cover during that initial interview with prospective clients?
That's a great question. And over the years, I've sort of developed a checklist. That's another footnote, in terms of trying to develop systems within your expert witness practice so you don't have to reinvent the wheel each time. So let me just walk through some of the highlights. Number one, are there any conflicts? Are you being asked to take a case adverse to somebody whose interests you're already serving as an expert witness? That's one thing. Is there a conflict? or it could be a business conflict. You don't have any cases, but it's somebody who sends you a lot of work over time, and you prefer not to be adverse to them. You don't have any legal obligation, but number one, are there any conflicts that you have? Number two, do you represent the plaintiff or the defendant, and maybe have them identify both parties? Or better yet, sometimes I'll ask them to send me a copy of the complaint. That'll help me kind of get the lay of the land. What is the key issue? Third point is, what is the key issue for which you need an expert? Because that'll give you an early read as to whether this fits within your strike zone and sweet spot as an expert. A fourth really important question, I think, is it in state or federal court? One reason it's crucial is because in federal court, there's a lot more that's required of a opinion and report in terms of rigor, thoroughness, and time, versus if it's in state court, you may just need, the client may just need a bullet point disclosure. So that's very impactful in terms of the written work product. Number five, really crucial. What deadlines exist for the report or disclosure, et cetera? And are they etched in stone, or are they negotiable with any wiggle room? That comes up a lot when you get these short fuse 11th hour proposed retentions. Another key question, how voluminous are the materials that need to be reviewed? And don't take generalities like, oh, not too much, or not too many, or there's not that, because invariably there are. I mean, I've learned the hard way spending Christmas vacation, using air quotes, going through multiple banker's boxes of documents right at the beginning of my career as an expert witness on a short fuse case. And I did not, you need to look at the deadline and the length of the runway that you have juxtaposed with the universe of documents. And I'll usually ask counsel in terms of number of banker's boxes, with the idea that a banker's box holds between 4,000 and 5,000 pages of documents. But before saying yes and locking into a date, that is really crucial. I think another point is to emphasize to retaining counsel that you don't know what your opinions are going to be until you review the material. I mean, and make that clear. They're not buying a hired gun in the sense of they're buying an opinion. They're buying my time. They're buying my expertise. And I won't know if I can help them or not. I can give them an impression based upon what they sketch out. But invariably what they sketch out, is black and white with very few shades of gray. And as I say, the flattest pancake has two sides. You're hearing one side of it from retaining counsel. But I try to make clear, both verbally and then later in my engagement letter, if it's just me and the firm, that I make no warranties as to what my opinion will be. I will say this, if I can't help them, I will tell them at an early stage. So those are some of the high points. If the stars align, then I say thank you for contacting me. I'd be happy to be a resource for you. If it's a direct engagement, not through an intermediary, I'll propose that I send them a draft engagement letter, take a look at it, and we'll take it from there. Look forward to working with you. And I always ask them how they found me. So, because you want to kind of track, was it by word of mouth? Was it through social media? Was it through a website? That's useful to know to steer your marketing efforts in the future.
Yeah. Well, part of the big thing that experts have to do is the depositions. And so, can you walk me through what is the practices to prepare for that look like on your end?
And I'm still working at this. I've given about 40 depositions. I've been engaged in over 130 cases. And of those, about a third of them have gone to deposition. I've got one on Tuesday. Number one, prepare for it like it's the most important exam you've ever taken, like defending a thesis or dissertation at a grad school level, because that's what it is. It is not an open book exam. It is not a written exam. It is an oral exam. So over prepare, both on the facts of the case and on the substantive analytical issues of the case, and show a command of the facts and the bases for your opinions. I don't think you can prepare too much. And that will pay dividends. It may take extra time, but that will pay dividends. because most cases don't go to trial. Maybe 1% of all civil cases go to trial. So usually the deposition is the trial. If you have a strong deposition performance, there may be less of a need for a trial because the case can resolve through summary judgment or through settlement. A third tip is to observe the Hippocratic Oath in terms of do no harm. And that is to tell the truth and make sure that your opinions align with the facts of the case. You're probably not going to win a case. My own theory, you're not going to win a case at deposition, but depending upon how you handle the case, you can hurt a case at deposition. You may crater a case. So align your answers with what you know to be true and with what you've opined in your report, and importantly, consistent with past testimony that you've given on other cases. That becomes increasingly important if you're not a newbie expert witness, because you're going to be questioned by very smart people who have spent a lot of time in advance of your deposition looking for ways to make you look incompetent, foolish, inconsistent, and to portray you as a hired gun. I think another idea is to yield ground in the deposition where you must. Every case has strong and weak points, and pick your battles with care. If there are issues where the facts clearly point in one direction, you have to yield and concede. Do that. Don't try to defend the indefensible. For example, I'm typically called in on issues involving insurance claim handling, and they're called bad faith cases. And there are a lot of, there's no such thing as a perfect claim file. There may be things that the insurance adjuster did not do. And if it's clear that they did not do them and maybe should have, then acknowledge that. That doesn't necessarily mean it's bad faith. That's a legal standard, and I'm not an attorney. But yield ground, pick your battles. Make a good appearance. That means your demeanor, your attire, your interactions not only with opposing counsel, but with the court reporter. More and more are on Zoom, but in olden days, and maybe in the future, if we're ever back to in-person depositions, greet and meet the videographer, the court reporter. Everything you do is on stage and noticed there, and have realistic expectations, because the deposition may not be the forum for you to make your case. I know early on as an expert witness, I would be frustrated because I'd come away from the depositions thinking, I never really got a chance to make my case. Over time, I've come to think if the other attorney is doing his or her job, you probably won't. That will come if and when the case goes to trial, and that will come on direct examination by your retaining counsel, who will walk you through the components of the case. The final tip here, Michelle, would be that the expert needs to make sure that they are assertive in scheduling one or more deposition prep sessions with retaining counsel before game day. There are some attorneys, if you leave it to them, they're very busy, I get it, but I'll talk with you in the parking lot, or let's meet in the conference room an hour before no, that doesn't work for me, at least. I'm sort of compulsive, and there are always issues that I want to address, kick around with counsel. And so I will schedule, whether it's by phone, whether it's by Zoom. A few times, again, in bygone days, it's been in person, but some substantive deposition prep sessions where you can kick things around. And if retaining counsel wants to do some mock deposition segments with you, I found very, very few who do that, but I think that's a great practice. But you have to push that, because if left to their own devices, a lot of attorneys, they're busy. They will not really schedule that. I need that. I want that. I would recommend that for any expert.
Do you usually have that listed in an engagement letter initially, or is it talked about in the interview, just to go back to that interview? Or is that something as it comes up?
Really, that's a good question, but mostly the latter. My engagement letter does not talk about that. It does talk about, in general terms, that they will agree to cooperate with me in preparing for testimony. And if there's I haven't had this yet, but if they ever just refuse to do that, there is an exit strategy mechanism. I've never had to call upon that, but usually as we get into the case, and I can explain why it's in their interest it's in their client's interests, it's in my interests. But even with all that, deposition and testimony is an anxiety-producing experience, even if you've done it a lot before. And if you're not nervous or have some anxiety, then good for you. But I say everybody has butterflies. The key is to make them fly in formation on game day. And I say I enjoy depositions the way I enjoy beating my head against the wall. It feels so good when you stop.
That's a really good analogy. Now, let's talk about the expert report. How do you go about writing that so that it's bulletproof or that it's the best it possibly can be?
I do try to make it platinum, but there's always gaps in the fortress there. But the first thing is to renegotiate tight deadlines, or decide whether or not you can meet a tight deadline. I quote the Nancy Reagan anti-drug slogan, "Just say no," because you are faced as an expert many times with these 11-hour hair on fire requests to review a couple thousand pages of documents or more, analyze them, come to some conclusions, draft, edit, and proof a report, and collaborate with counsel, and to produce a polished work product. And so I want as long a runway as possible. So if there's a tight deadline, and by tight, a lot of it depends on the volume of material. There are a number of variables here, but I like at least 30 days, if not more, from the date I'm engaged. That means the contract signed, retainer received, materials received, those three things. That's when the starting gun goes off. Even then, that's aggressive. So I think really allow yourself enough time so that you can do something other than microwave an opinion. We're experts. We're not short order cooks. Would you like fries with that? And so the more time I have, I think I speak for a lot of experts, the better job I can do for the lawyer, the law firm, and the client. So that's number one. And a lot of times, if you push back and say, if I had X amount of time, I could do it, or can you talk with opposing counsel, or can you request an extension from the court? I've had, not always, pretty good luck. At least ask, okay, number one. Number two, give yourself permission to write a crappy first draft. And that is, I think a lot of people, they feel they've got to put something down that's extremely profound. Get something on paper or on the computer screen. Give yourself psychological permission to throw it against the wall with the idea that some of it may come off, may be scraped off, maybe cleaned off, but eliminate some of the psychological friction and resistance to starting. Number three is eat the elephant one bite at a time. You probably have a number of issues to address in the report, and maybe just each day take one of those issues that you're going to think about and you're going to compose or draft some thoughts on. Break it like any big project that just seems, oh my gosh, overwhelming. How am I ever going to climb that mountain? It's 26,000 feet, Everest. You do it one step at a time. You break it down. You don't look at the summit. You look at the steps in front of you. You look at the 6 feet in front of your face, and you keep, step by step and chipping away at it. So, and get clear on what your report, what it has to address. And there may be issues that you don't need to address, or maybe another expert is addressing those, or that's just something that retaining counsel does not want to. So get clarity with retaining counsel. Also get clarity on whether the written work product is a full-blown Rule 26 report or a bullet point kind of disclosure. If you're doing a Rule 26 report and that's not needed, that may be overkill and will bloat your bill and maybe much more than the attorney wants. So get on the same page with retaining counsel. Proofread, but don't rely solely on spell check. By all means, use spell check. But there's some things that even spell check won't catch. And my mind, probably not different from any other expert, my mind will insert words that I meant to put there, but I'm so close to the manuscript. That's where, if retaining counsel takes a look at it, or if somebody else takes a look at it, You develop mental blind spots. There's also software programs like Grammarly or WordRake. Some have a free version, some you have to purchase that will, spot grammatical and other errors. Maybe get somebody who knows nothing about the case. I'll tell you, sometimes I'll have my wife read through a report. She will catch things grammatically, spelling, and other things that I'm blind to. Or somebody who knows nothing about the case can say, does this make sense or not? She can be brutally honest with me, and that gives me a sounding board. So, I mean, you're going to be asked, who else have you talked to about the case? But so I don't go beyond, using my wife for that purpose, but I'll have somebody that knows nothing about the case. And then I would say appearances count, look sharp. I mean, there's a book called Typography for Lawyers by a guy named Matthew Butterick. Again, I'm not a lawyer, but you don't have to be. The principles in his book on how to make the manuscript, obviously substantively, it's got to be sound, no typos, proper grammar, but formatting and appearance counts in making it look good. And my final thought, my random thought is ask and clarify with retaining counsel whether they want to see drafts or not. Because different lawyers in different firms in different states have different philosophies and approaches. Some of them say, I do not want to see your drafts, maybe because of discoverability issues or whatever. Others say, yeah, I'd like to see a draft. So before you send a draft to retaining counsel, be clear on whether they want that or not. And I'm cool either way. If they don't want to see it, that's fine. Sometimes in lieu of that, they want to talk about it over the phone or do a screen share. But I don't know if that makes the report bulletproof, but I think, it's got to be free of, you want a meticulous written work product, free of typos, free of grammar problems, that analytically makes sense, that's well organized, that is easy on the eyes in terms of paragraphs and transitions, and is graphically tight and attractive to read.
Well, lastly here, you have a wonderful website that talks about yourself, and you have good information that people can dig through. What is the best way to market yourself that you found over the years?
Well, not to overlook the obvious, but aligning yourself with an expert referral service like RTG, it provides what I guess the military would call a force multiplier to kind of broadcast your eligibility and expertise and to cast that fishing net. So that should certainly be one fishing line, I think, in the pond of business development. A second tip would be strive to be what I call a thought leader in your subject matter area, no matter what it is. Again, whether it's metallurgy, whether it's kidney specialist for a doctor, whether in the insurance realm it's underwriting or coverage or actuary, whatever subject matter domain, try to be a thought leader. How do you do that? You write articles, you speak at conferences, you blog, you speak on webinars, you speak on podcasts, and you generate content, not content that says, I am great and this is why you should hire me, but actionable insights and tips that will be read by folks in your domain. That's how I became an expert witness. I had no plan to be an expert witness, but I was writing, I was speaking, I was attending industry conferences, and there came to be a time when I was in the corporate role, I started getting these unsolicited phone calls from law firms to serve as an expert witness. I had no idea what they wanted, and I had a full-time job, but I took one or two on sort of a moonlighting basis. And I kind of fell into this by accident, simply because I think, and I had collaborated on textbooks published by the Insurance Institute, the American Insurance Institute in Malvern, Pennsylvania, and overtures started coming to me. So that shouldn't stop once you become, but it positions you as a thought leader. And it all ties into what I call content marketing. I didn't develop that phrase, but I am very big on that in terms of not promoting your practice but promoting your practice by generating useful content that would be interesting to your target audience, and positioning you as a thoughtful commentator on events in your field. Now, footnote, expect all of that to be researched by opposing counsel in terms of opposition research, like in a political realm. That's a whole specialty. So whatever you write, and whatever you speak about in your handouts likely will be scoured. I get that. That's part of the game. There's some experts who say that's why you should not publish. I don't believe that. How do you get to be an expert if you don't publish, if you don't speak? But this is just my own personal rant here. So another tip is to develop a database, start building a database of law firms and attorneys who work in the arena that you are commenting on. For example, I'm an insurance claims handling specialist. There's a number of firms have specialties in insurance coverage defense and bad faith defense. So you start seeing through conferences and through reading and social media what attorneys and law firms are corresponding thought leaders in the legal aspect of it. They're defending insurance companies, or they're suing insurance companies, and they need specialists who can opine on whether or not the claim was handled in accordance with industry standards. I think it's one simple way is to quote Steve Martin, the comedian, had an interview with Charlie Rose at one time. And the phrase that Steve Martin brought up was, be so good they can't ignore you. Okay, now that's a tall order, but essentially once you start getting an assignment, 1 assignment, 2 assignments, 3, do such a good job, okay, honor all deadlines, meet or beat all deadlines, be easy to work with, provide a meticulous work product, prepare like hell, prepare exhaustively for deposition and trial testimony. That's the blocking and tackling, and do it so well that when the case is over, whether they prevail or don't, or somewhere in between with a negotiated resolution, they feel that person has it together. They will tell their partners, their colleagues, people in other firms, keep your CV and resume on file. And so I think I would say, it sounds simplistic, but it's hard to do. Be so good that they cannot ignore you. Most of my referrals come from word of mouth. I don't pay for any advertising. They always ask in the deposition, Mr. Quinley, do you advertise? And I don't pay for ads. Lawyers pay for ads. I mean, it's fine for them. They're on TV, they're on billboards, they're on the radio. It's fine for them. But oh my God, for an expert to advertise. But I digress. I don't pay for any ads. I have a website, like about every law firm does, if you want to call that an ad, but it's more informational than saying, I will help you win your case. I make no such claims. But I will say, I'll give you the straight scoop, my own perspective. If that helps you win, fine. If it doesn't, that's not my problem. This is my opinion. So the final thought on this, Michelle, is to not be shy to ask for referrals for attorneys and law firms that you have worked with, or even if they don't have a need for you, if you cold call them, or if it's more than a cold call, a warm call, just say, here's my CV. Please keep it on file for future needs. Share it with your colleagues. If you're generating content through content marketing, whether it's a blog post, whether it's an article, whether it's handouts from a conference or a webinar that you've spoken at, say, here's an article that I wrote on such and such topic I thought you might be interested in. Put it on a calendar diary every 90 days, every 180 days to cultivate top of mind awareness in law firms, so that when that need comes up again, you're the person that they think of, or at least in the running for.
Yes, that was all wonderful advice. And definitely, I think as we adapt as a society, all of us really do take on those bigger roles in the marketing world. I mean, you wouldn't think back in the day that you would have to play and wear all these hats, but it's so integrated now that it's really something you do need to know how to do.
Well, and it's not easy. A lot of people, don't find it comfortable, but as again, stealing a quote, I don't know the source. One guy who's a successful consultant said, if you don't toot your own horn, there's no music.
It's very true. Well, Kevin, I really appreciate all your time today and your insights. Thank you so much.
My pleasure, Michelle. Thank you.
Thank Thank you for listening to our podcast, Discussions at Roundtable. Our show notes are available on our website, roundtablegroup.com. Subscribe today on Apple Podcasts or your favorite listening apps.